12, Skills-Based Training. Part 3, Topical Areas Applicable to All Proceedings. Sections 11 through 14. As a GAL, your goal is to help find and get the child to a placement that you have determined to be in their best interest. In order to get this goal, there are a few topics that GALs need to be sure they are familiar with in order to move the process forward. These include topics of permanency, termination of parental rights, appeals, and other collateral judicial proceedings. Let's start by examining permanency and its importance for children. The Adoption and Safe Families Act clearly and unequivocally establishes 3 national goals for children in foster care: safety, permanency, and well-being. Permanency is achieved when children are returned to their families, when children are adopted, or when children are placed with individuals who are their permanent guardians. The hierarchy of permanency is reunification, adoption, guardianship, and placement with a relative or an alternative planned permanent living arrangement. With OPLA, the Child Welfare Agency maintains care and custody of the youth and arranges a living situation in which the youth is expected to remain until adulthood. OPLA, or APLA, is a permanency option only when other options such as reunification, relative placement, adoption, or legal guardianship have been ruled out. It is the least favored of the permanency options. Regardless of the options being pursued, permanency hearings must take place no later than 12 months from the date of the child's removal and every 12 months afterwards. They are also held within 30 days of determining that reasonable efforts are not required. The court makes a determination of reasonable efforts as outlined in Wyoming statute and also determines whether the permanency plan is in the best interests of the child. As discussed in previous sections, at the permanency hearing, DFS tells the court what efforts have been made towards the permanency plan for the child, addresses other options for permanency, examines reasons for excluding permanency, and presents a plan to carry out the placement decision. DFS must also present to the court a compelling reason for establishing a permanency plan other than reunification, adoption, or legal guardianship. According to sources found on the Child Welfare Information Gateway, there are several strategies to enhance permanency. These include maintaining children safely with their birth families, maintaining relationships with relatives, and using guardianships. If possible, involving the youth in planning his or her own permanency is an excellent strategy. In any case, you should always ensure appropriate and timely services and strengthen court supports. Due diligence must be taken to search for family members of a child in DFS custody, including grandparents, aunts or uncles, and other family members. DFS is responsible for this family search, and it begins at the very start of the case and continues throughout. As a GAL, it is critical that you ensure diligent searches for parents occur, even if and when a parent is deported. Failure to conduct diligent searches for parents can be raised as issues in termination of parental rights cases and appeals, thus affecting expeditious permanency for your client. Understanding how to define permanency, the permanency hierarchy, the requirements of the permanency hearing, and identification of resources and approaches to permanency, including adoption and guardianship, are all key skills you will need as a GAL. Refer back to this section as needed when you are considering permanency options for your client. While reunification is always the priority for child permanency, there may come a time in your advocacy for a child that it becomes apparent the child cannot return to his or her parents and TPR is required. A termination of parental rights is a balance of 3 competing interests: a parent's fundamental right to parent their child, the child's right to safety and permanency, and the state's interest in protecting the child. Parents, guardians, or legal custodians, or DFS, may file a petition for TPR. Once the TPR has been filed, the court will appoint a GAL to represent the child. In this section, we will explore the issues a GAL may face when TPR is required. In Wyoming, there are 8 separate grounds for a termination of parental rights action. One ground is that the child has been left in the care of another person without provision for the child's support and without communication from the absent parent for a period of at least 1 year. Another is that the child has been abandoned with no means of identification for at least 3 months and efforts to locate the parents have been unsuccessful. 3 is that the child has been abused or neglected by the parents and reasonable efforts by an authorized agency or mental health professional have been unsuccessful in rehabilitating the family or the family has refused rehabilitative treatment. 4 specifies that the parent is incarcerated due to the conviction of a felony and a showing that the parent is unfit to have custody. Number 5 is that the child has been in foster care under the responsibility of the state of Wyoming for 15 of the most recent 22 months, along with a showing that the parent is unfit to have custody of the child. The grounds in number 6 provide that the child was abandoned at less than 1 year of age and has been abandoned for at least 6 months. Number 7 is that the child was relinquished to a safe haven provider in accordance with Wyoming statute, and neither parent sought return of the child. And finally, the parent is convicted of murder or homicide of the other parent. Take note here that more than one ground may be alleged, but only one must be proven with clear and convincing evidence to terminate the parental rights. Under federal law, TPR proceedings are required for children who have been in foster care for 15 of the most recent 22 months, infants who have been determined abandoned, cases in which a parent has killed another of his or her children, or certain other egregious situations. Keep in mind that Wyoming statute states that the court may appoint an attorney for any party who is indigent. If parental rights have been terminated, options for placement of the child include adoption, kinship care, and adoption by foster parents. If the TPR is denied, the court's options are to dismiss the TPR case. The court may put in place a 6-month reasonable efforts order. The reasonable efforts order allows DFS 6 months to make reasonable efforts that weren't made while the TPR case stays open. The GAL program employs a permanency attorney who handles the GAL representation for program clients in TPR and appellate procedures. This section is meant to help you participate in these proceedings and help you prepare the underlying juvenile action appropriately. The outcomes of a case may not always be what a GAL has determined is in the best interest of the child. In the event that the court's decision produces an unfavorable outcome for your client's best interests, you may file a notice of appeal. An appeal subjects the entire case, including the facts and the law, to review by a higher court. Note that any party to any juvenile court case can appeal, including you, as the GAL. Let's take a few minutes to become informed about the appeals process and build an understanding of what are the appropriate actions during the appeal process. You must decide whether you should appeal. The first step in this process is to determine whether the order in question is appealable. In general, the final judgment rule, in which appellate courts cannot review any rulings for which any further judicial action is required by the courts, is in place. However, there are a number of exceptions to the final judgment rule. Next, you must be aware of time limits in filing the appeal. In Wyoming, the appellant has 30 days from the date of the judgment to file. If you think you have an appealable issue on behalf of your client, you should consult with the program administrator or permanency attorney immediately, so the two of you can determine if it is an appealable issue and when to file. All appeals must be approved by the program director. Initial stay requests should be filed in the trial court. Whether the stay is granted is dependent upon the likelihood of hardship or harm to the child if the stay is denied, whether the appeal has merit and is taken in good faith, the harm to the non-moving party if a stay is granted, and any other considerations which may be present. Temporary stays can be requested while the stay request is pending. If a stay is denied, the petitioner may seek a stay in the appellate court. In your role as GAL, you are required to inform the court of any subsequent events that may cause an appeal to become moot. Evidence of these events may be presented to the court in the form of a motion to take judicial notice, a motion to take additional evidence, or a motion to dismiss the appeal. Since the permanency attorney will be handling the appeal, you need to stay in close contact with him and inform him of any changes that may affect the appellate proceeding. A writ is an original proceeding asking an appellate court to command an inferior court to do something or to refrain from doing something. The parties to a writ proceeding are the petitioner, who is beneficially interested but was not necessarily a party to the lower court proceeding, the respondent, the court and judge whose action is being challenged, and the real party in interest. There are two criteria that must be met to qualify for writ relief. First, the petitioner must demonstrate that he or she does not have a speedy and adequate remedy in the ordinary course of law, such as through the appeals process. Second, the petitioner must also show that any failure to grant relief will place the petitioner at risk for irreparable harm. Since writs are heard more quickly than appeals, this option may be a consideration if these two criteria are met. As a GAL, there are a handful of other court proceedings that may either run parallel to a juvenile court case or arise out of a juvenile court case that you should be aware of. We will take a few minutes to cover them here. A criminal case is sometimes filed against the parent at the same time as the juvenile court proceeding. It is important to understand that these cases have their own timelines to follow and cannot wait for each other. Pursuant to Juvenile Court Rule 10, as a GAL, you should advocate and ensure the juvenile case proceeds in a timely manner in spite of the criminal case. They will also likely have completely different attorneys involved. Remember that the juvenile court case is confidential, so extreme caution should be used if information is requested from the juvenile court case for the criminal court case. With that said, you should follow this proceeding and keep track of its progress. If the case gets to sentencing, you may need to assist in preparing your client to testify at the sentencing hearing. If the child is young and you think it is in his best interests, you can consider writing a statement on his behalf. These are tools at your disposal as long as you are only sharing information that is in the criminal court case and not confidential to the juvenile court proceeding. If there is domestic violence present in the family, there could be a domestic violence protection order in place. The parent could also seek this while the juvenile court proceeding is open. Be sure the court and DFS are aware of this proceeding or order if there is one. The parents could be involved in any number of private actions, including establishment of paternity, child support, child custody, divorce, or a private termination action. Sometimes it is in the finalization of a private custody proceeding that needs to occur before the juvenile court case can close. If this is the case and the family cannot afford an attorney, refer them to the Wyoming Center for Legal Aid or the Wyoming State Bar. Other legal aid providers in Wyoming are listed in your GAL Handbook, Part 3, Section 14. Adoption and guardianship proceedings are two cases that may arise out of the juvenile court proceeding in order to effectuate permanency for your client. Many times, adoptions and guardianships are separate court actions, and as such, the GAL is not party to those actions. Adoptions and guardianships can be filed within the juvenile court action, however, and if so, the GAL is a party to the action and entitled to be present. Either way, you should be aware of these and track their progress to ensure they are completed timely. Also, be aware that the family adopting or taking guardianship of your client may qualify for subsidies, if needed, especially if the child has significant health needs or is an older youth. We have now reviewed 14 different topics that you may face in proceedings as you advocate for your child clients. These may come up at any time with little warning. Be aware of these potential issues. The more you know, the better the service you will be able to provide to your client.